The court was clearly sympathetic to her dilemma. She could not remove her headscarf for a job interview without remaining true to herself, and Abercrombie refused to hire her because she was true to her religious beliefs. Now they're trying to claim they didn't know she was religious, but employees should not have to wear a sign that says, "I'm religious," before they are protected by our civil rights laws.
All right, ladies and gentlemen, I got to tell you, I would never open a business. I'm sorry. This is just, to me, this is nuttiness. But Kendall Coffey, who will tell us what the law says and what the court said yesterday, joins us. Of course, partner at Coffey Burlington, LLC, former Florida U.S. attorney. Kendall, great to talk to you. Two rulings from the U.S. Supreme Court yesterday, and one involving this Muslim woman who went to apply for a job at Abercrombie & Fitch and had a headscarf on, and they didn't hire her, and they claimed they didn't know she would have to wear that for the job, but the court said it doesn't matter if they knew. But the bottom line here is a place like Abercrombie & Fitch, to me, they're all about image. And if they have a dress code and they want to present a certain image to get people in, to get people to buy their clothes, and they're all about clothes, and someone has to wear a certain type of clothing that doesn't conform or fit in with the image, why should they be forced to hire them?
Well, you had an overwhelming majority of the court that said that you could be violating religious discrimination laws. The voice of the dissent in the case, and this was the position of Abercrombie, was, look, they have a neutral look policy. They are looking, it has nothing to do, according to Abercrombie & Fitch, with religion or who you are or what your beliefs are. They're looking for a particular image without any kind of caps. So from their standpoint, whether it was a Yankee cap or whether it was some other item of headwear, that's not their concern. They viewed it as completely neutral. Of course, the court held differently because, as a woman of the Islamic faith, she felt a need to wear a scarf, and she should have been, according to the court, accommodated in some fashion. So it's is it intentional discrimination? One wouldn't think so, because there was no evidence that they were trying to single out or discriminate against Muslims. Nevertheless, the case turned on the view of the statute and that you have to accommodate somebody and, in a sense, make exceptions, even though the policy itself is neutral.
All right, let's go to the next one. A guy puts threatening lyrics, rap lyrics against his ex-wife. She gets an order of protection. They call the FBI. They arrest him. How could you be allowed to threaten someone on Facebook, even though the guy didn't intend to go ahead with it, if you're scaring that other person?
Well, and once again, it was an 8-1 decision authored by the Chief Justice, who said that it wasn't enough to constitute a crime. And Steve, you looked at some of the words. They're pretty vivid and dramatic.
Yeah.
This wasn't like saying, I'm mad at you, I'm going to get you. It wasn't anything general like that. It was like suggesting that his ex-wife for Halloween ought to be a head on a stick. And basically talking about a crazy man in a kindergarten class.
Yeah, shooting up a school.
So the much more explicit threats of violence than one would normally expect you could get away with. But here's what the court said. They said the issue isn't.
Yeah, go ahead.
It's not whether it's crude, degrading, or violent, because the court said it is, but you have to prove, because it's a criminal law,
that he was going to go, that he had intent to do it, right? That he had intent to do it.
Got to be an intent.
Yeah, Kendall, crazy rulings in my view, but thanks for filling us in. Always appreciate your time, Kendall Coffey. We're coming back with Brent Badowski. Don't go away.